Today we are here with Michael Hull. He is an ASU alum, and he is with Hull Curry Law, and he is a managing partner there. It's a law firm specializing in venture capital, finance securities, technology, licensing, mergers and acquisitions, international and national business transactions. And his specialties are working with investors and startup entrepreneurs, advising board and leaders in fast-growing companies, building board and executive teams. And Michael has chaired or served on the board of Arizona Venture Capital Conference, BioExcel, AZ Tech Investors, and the Indus Entrepreneurs. So thank you, Michael, for joining us here at GenLabs.
Thank you.
And if you guys have any questions for him, we'll do this more of like a question and answer kind of way, and then we can go from there.
Yeah, let me suggest something like kind of a if you're thinking of starting an enterprise, or if you just got started and you don't really have everything together yet, there's kind of some basic things you should be thinking about. One is, what do we do at the formation stage? When should we form an entity? That's one thing. And then what kind of entity should we be? And then what are the couple of key, most important things that you have to make sure you take care of going? And then from there, it depends on, what type of business you have and, what your trajectory is in terms of, are you going to raise outside capital? Are you just going to bootstrap? Things like that. So then we can kind of get into a few areas there. So what I would say, let me just take 5 minutes or so and get this started. What I would say is if you have let's say you just have an idea and maybe you have a co-founder and you're working on your project, you want to form an entity as soon as, certainly before you take in any money, right? You don't want to bring in any money until you have an entity. Sometimes you need to have an entity to have a place to put IP that you create or that other people will be creating, to kind of bring it all into one spot instead of having a lot of people potentially being inventors floating around and then they disappear. So that's kind of when you want to form it. If you have the luxury, for one thing, forming an entity demonstrates your commitment. So what very early stage seed investors, friends and family, even potential partners that you're dealing with, especially if they're in industry already, they're looking for signals, because when you're just getting started, especially if it's your first time, they don't want to invest a lot of time and effort unless they know you're committed, and you've got to demonstrate that you're committed 100%. So you have to think about what kind of signals am I sending when I'm talking to somebody about my potential business opportunity. Is it just a hobby? Or are you going to play around with it a little and see if it works and then just walk away if the going gets tough? People that you're going to be sitting across from will be looking for signals around, what is your real commitment to this? Because if you're not committed, they're not going to be committed. It's just a fact of life. Everybody's busy. So on that theme, if you have the ability to do it and you are committed, I think it's important to go ahead and form an entity. It's pretty simple nowadays, but that's one thing that does demonstrate your commitment. It's like, look, I've already created an entity. We're taking this seriously. We treat this as a business. So that's one way to think about it. The only reason why I wouldn't form an entity if you're kind of in the ideation stage is if you really don't have any money and you don't want to do it because you really literally don't have the money. It's between eating or forming a company. But it's relatively inexpensive. So it's a couple $100 to form an LLC, and that's an easy way to get started. So I would recommend it as soon as you reasonably can if you're committed to doing it. So when you get to forming an entity, you have to think through, well, what's the best thing I should do? Should I form a corporation? Should I form a limited liability company? I don't know if you guys know what the differences are, but a limited liability company is sort of like a partnership. And it's created by statute, just like a corporation is. And it gives you limited liability for the business that you engage in, so you can't be personally liable if something bad happens, and your creditors can't sue you. But it's treated as a partnership under the law. So even if it's just you, it's kind of a weird thing that you can be a single member LLC, but under the law you're treated like a partnership. Don't know how that kind of logically works, but and a corporation is similar. It's just not treated as a partnership, and it's a little less flexible. So a corporation has the relationships of the people that are involved in the company. You'll have directors, a board of directors, you'll have officers, and you'll have shareholders. And generally speaking, all of their rights are defined in the statute. So you don't, once you form a corporation and you identify who's on the board, it could be the same people that are everything. You have two people, they could be the only shareholders, it could be the board members, it could be the officers. But you don't have to define any of those roles. They're already defined in the statute. On an LLC, on the other hand, you have total flexibility to do whatever you want. So if you form an LLC, you have to create what's called an operating agreement that defines what the roles of the people are. So it's not already pre-planned for you. So it gives you maximum flexibility as an LLC. And it's the cheapest way to go. So I would start out as an LLC. By the way, I do a lot of work in Silicon Valley and here, so whenever I talk about this stuff, it's kind of interesting to compare and contrast where it's helpful. But in Silicon Valley, because of the influence of venture capital, it's about a 75% startups there form Delaware C corporations, because that's what venture capitalists invest in. So people start off right off the bat, they just form a C Corp in Delaware and they don't take any interim steps. They just jump right in. However, outside of Silicon Valley, the rest of the nation, it's almost flipped. It's about 70% of America, in the United States anyway, form LLCs to start. So it's just kind of interesting, the influence of venture capital. But even within that, within Silicon Valley and elsewhere, of course, but are you guys familiar with Y Combinator? Yes. It's an accelerator program that's very well known, and they generate a lot of very successful startups. Well, Y Combinator has their startups form as LLCs, and then they flip to C Corps when they're ready to bring in the institutional money. So even within Silicon Valley, there's pockets of people that have a philosophy of, let's just start out as an LLC because it's the simplest thing to do. We can always change it later. So that's even in the heartland of venture capital that is mostly dominated by C Corps. There's certain pockets that are philosophically just made the commitment to form LLCs first because it's easier. So what I recommend typically is, if you're just getting started, form an LLC, because it's really easy later on to re-domicile and flip it into a Delaware corporation when you need the money. So anyway, that's forming a company. And then the common questions that I get are, well, what should we be doing next? Let's say we have limited money. And there's not a need for a lot of things. So what's the minimum we should do? What I always say is you want to make sure that you document the ownership, right? I can tell you so many war stories. I've had companies where founders have come into me and they say, oh, this guy's got this, she's got that, and I look at it and I add it up and I say, well, you can't possibly do this because you have 150% of your company is owned by you guys, so it can't be. So in other words, people are throwing around, you get 10%, you get 30%, they promise people stuff, but they never really add it up, and it's like, you guys have to huddle again because you can't have 150% of the company. That's actually happened a few times. And usually it happens because, just an example, people working on software or something, there's promises made, they'll send emails back and forth, we'll give you 10% of the company if you do this. And then they lose track of who they sent the emails to, and then people show up at the table that when you add up what everybody says they have, it doesn't work. It's over 100%. So it's really important right up front to document who owns what, and we create what we call, I don't even know if this is going to be helpful. I'll go to a couple things if we need to. We go to you want to create what's called a cap table, capitalization table, and it lists each of the founders and how much they own. And then it also has a reserve for future issuances of equity. And you do that for an LLC, you can do it for a corporation, but it's really important to do that. And then, if you're a corporation, you'll issue stock certificates. And if you're not, it'll be embodied in the operating agreement that you create. It'll say what everybody owns. So that's one thing. You want to make sure you document that. The other thing that's real critical is, I'll give you another life story. This is actually a true story. Client of mine, they've raised $19 million. The two principal founders are no longer with the company because once big money came in, the CEO, who was really a technical person, became the CTO, and eventually he went off and did other things. But initially they were 50-50, two founders. One was actually a surgeon and one was an engineer. And they came together and they said, okay, he's got 50 and he's got 50. And I said, well, what happened? Don't you guys want to make sure you earn it over time or anything? They're like, no, we're 50-50. In fact, it's kind of insulting to them to say we have to earn our own stock when it's just us. The problem is, about a little over a year into it, the doctor decided to move to Hawaii and stop participating in the business. So what happened is that company grew up. We had no way of getting his stock back, and he wasn't adding any value. The engineer stayed and worked his butt off, brought in other team members, was still in charge when we brought in the first few rounds of capital. So essentially, he did all the work for the same equity as the other guy that put in a year's worth of very little work, nothing. Wrote some papers and stuff in the beginning. That guy's going to be a super millionaire, and he hasn't contributed at all to the business. The problem in that whole situation is that they didn't vest their equity. So if you're coming together and you're getting a percentage of the company based on an expectation that you'll contribute, you have to make sure you earn it over time. So it's good for you, it's good for your partner. So you don't know which side you'll be on. You should always assume, what if my partner leaves? So what you want to do is, if that person's no longer there, whatever they had, usually it's called vesting. So over time, let's just take a simple example. If you vest over 2 years and you do quarterly vesting, right? So that's 8 vesting periods. And so each quarter you vest 1/8 of the amount of your 50% of the stock, if it's 50-50. So, and all that means is you are 50-50, but if you left in the middle of the second quarter, you would lose 7/8 of your 50%. It comes back to the company. So it's all you're left with is that equity that relates to the time period that you were actually there. That's really important for a couple reasons. One is the person that's left will curse himself and his ex-partner for life for not taking care of it, like my example, which is really what happened. But probably more importantly than that is you want to have that equity back so you can find that person's replacement. Because usually in a startup, you don't have money to hire people, right? So you're using equity as compensation. So if you don't get that equity back, then it's going to dilute everybody, when it shouldn't. It should come back from the person that's no longer there. And the same principle applies if you have 5 people. It's just that when founders are coming in and they're getting equity for participating in the business, it's called sweat equity, you want to make sure it vests over time. And by the way, the first time you raise money from a serious seed investor, I'm not talking about friends and family who might not really think of these things. But if you go to an organized angel group or a seed fund or something like that, they will require you to vest. So if you haven't, they'll make it a condition of their money coming in that you enter into agreements to vest your shares over time. So it's just a fact of life. The money wants the sweat equity to have vested, and they want to make sure you've earned what you say you're getting. So that's a really important thing. And whenever people ask me, like, what are some top startup mistakes, that's probably one of the most catastrophic ones if you don't do it right. The good news is it's pretty simple to take care of. And it's rare that people don't do that if they're bringing in investor money, because it's just going to be, forced upon them. The other thing that's probably the biggest mistake is not tracking your intellectual property. So if people are, I'll use the example of people writing software code, because this is where it comes up a lot. You'll have team members, and some people will be working on code, and people will be doing different things. And if that's not documented anywhere, I've had this happen many, many times. Well, 1, 2, 3, some of the people that wrote the code are no longer there. They leave, and they're not part of the team anymore, and there's no documentation. So it creates a problem in terms of the ownership of your IP, because basically whoever creates it is the inventor, and they own it, right? So what you want to do at the startup stage, it's real simple. It's you can even do it on a little tiny one-page document. But it's called an invention assignment agreement. Sometimes you call it a proprietary rights agreement. But it basically says, let's take the example, you have 4 founders and 3 of them are writing code. Everybody signs, even if you're not writing, everybody should sign this anyway. But it says, everything I create in furtherance of our business belongs to the company. And there's a clause in there that assigns it into the company. So that's another reason why it's important to have an entity. So if you have an LLC, and you have people working on it, and this could apply to any IP, it doesn't have to be software code, but everybody signs one of those, and it's clear that it belongs to the company. That way, if anybody leaves, you don't have to worry about it. So the reason why that's critical is you want to make sure you have ownership, but when you're dealing with third parties, if you're going to do a joint venture with somebody, a joint development agreement, or if you have an investor coming in, they're going to want to see that paper trail. They're going to want to know that an investor will not put money in, or they're going to be very uncomfortable putting money in, if you can't demonstrate that you own all your IP. If there's a hole in it because somebody worked on it and is no longer around, they're going to say, go get that person to sign an assignment. And if you can't find that person, it could blow your deal. They may not put money in. So it's really important. That's a simple thing to take care of, but it can be a big mistake. So it's sort of like the vesting for equity. That's probably, about as equal of a problem. So those are probably the 2 biggest startup mistakes. So those are easy things to take care of. So you form your entity, you make sure your team knows who owns what, and that's documented. And then you make sure whoever is working on anything that creates any IP signs this document that says it belongs to the company. And then from there, it depends on what you're doing. So we can talk about other stuff now. So that kind of lays it out there from start. A couple things just to get you launched. I don't know what you guys want to talk about. If you have any questions, we can talk about financing or anything else. So
this is Malin, by the way.
Oh, hi.
hi, how are you?
Sorry for walking in.
You're totally
Late.
fine.
Wasn't aware, but
I don't know, maybe later stage IP, how do you handle that?
Well, what do you mean, how do you handle it?
So patents versus copyright and that whole process, how do you get that?
Well, okay, so the way we personally, I'm not a patent attorney. Like, I don't file patents, but I've done licensing. In fact, I've done licensing for ASU. I created all the documents for AZTE, for example, that they use today. And so I mean, because technology is probably the principal asset in most of our companies. So we're dealing with IP all the time. A lot of licensing, a lot of co-development agreements, all kinds of things. So this is how I look at it. I put IP into buckets. You got to know what kind of IP it is, right? And once you know what kind it is, then you think about, what do we do for that category, that bucket of IP? So there's things that are patentable, there's things that are copyrightable, there's things that are just trade secrets that you can't patent or copyright, or you might not want to for various reasons. And then there's trademarks. That's the basics of how you think of things and the things that you might protect. Patent is is asking the government for an exclusive monopoly on your idea that you can reduce to practice, that you can demonstrate that you've reduced it to practice in some way. And the person that files first under the new rules wins. So it's not enough just to have lab notes, it's whoever files first now, which is a big distinction. It used to be, I'm not sure exactly when the law changed. It was like 2 years ago or a year and a half ago. And it wasn't too long ago. Might even been longer than that. But it used to be that it was whoever could demonstrate through their evidence, usually it was lab books, of who the inventor was, would win if there was ever a dispute. But now it's first to file. So that's critical to just understand and think through, when should I be protecting something that's patentable. There's a key thing that when you're dealing with something that is patentable. Once you disclose it, once you make a public disclosure of that idea, then basically you're going to have a year before you lose it, right? I mean, you lose it if you disclose it without any kind of a contract, or like you can protect it by having a confidentiality agreement, a non-disclosure agreement. You can disclose that idea to that person and it doesn't start a clock ticking. But if you disclose a patentable invention publicly, then you lose it when you lose the ability to patent it. But even if you do sign an NDA, once you disclose that publicly, you have 1 year to file everywhere else in the world, or you lose that. So there's some specific timing things that you need to think about if you're working on anything that that is patentable. A copyright is different in the sense of it arises automatically when you create something. So when they created this, or if I create a song lyric, or I write a book, or I write software code, or I create a website, just by creating something tangible from my idea, the minute you create it, you own the copyright to it under the U.S. law. And there's some things that are important to know about what you do, but you get certain third parties that are out there in the world. You're supposed to protect, if you want to protect it, you're supposed to put a copyright notice on it and state the date. So that puts the world on notice that you're claiming a copyright to it. It doesn't change the fact that you own the copyright. It just gives you certain procedural advantages if you're in dispute with somebody else who might have something similar, or you need to prove that they stole it from you. You can also file a copyright with the Copyright Office. So a lot of people that do software and things, they don't file. They don't bother filing because they don't want to get anything of record, and they're updating it all the time, and there's various reasons. So, but you do want to put a copyright notice, like on a lot of software you'll see the copyright notice in the beginning, or on websites you'll see the copyright notice. You do want to do that. The benefit of filing a copyright is it establishes an indisputable date when you know you owned it, because once you file it, it's of record with the Patent and Trade or the Copyright Office, and so you don't have to prove anything. You know that was on file there, so nobody can really dispute that you had it back then. If you don't have that, then it creates factual disputes. So that's one reason too. The other reason is there's some statutory damages you can get if you sue somebody that's violated a copyright that you have filed. If you filed it, you can get extra damages. So that's another reason why sometimes to do it. You can file a copyright anytime. If I create something, if I write a book, I can file a copyright 2 years later. I don't have to file it right away. There's no timing issue. It's just because you own it right when you create it. It's just you don't get the benefits of those extra damages if you sue somebody and stuff until after you file. So anyway, trademarks are it's any kind of mark used in connection with the sale of products or goods. A service mark, same thing as a trademark, it's just in connection with the sale of services. So I was going to say, this little thing here, you can't see it, but there's a little circle R on that. That means ASU has filed and they've registered their trademark for that logo, that little circle R. So once you've registered a trademark with the Patent and Trademark Office, you're allowed to put that on there. But what the benefit of that is, a trademark arises out of the date you first use it. So it's sort of like a copyright. It arises right away when I start. As soon as I put a mark that I use to sell a product or service, that's a trademark or a service mark. It's just that the way the law works is the first to use the mark in connection with that good or service in a particular market wins and has superior rights to anybody else, and you can stop anybody else and you can sue them. The problem, if you don't file a registration, is defining the market, right? So like if I have a restaurant in Tempe and I call this is an example from Arizona, Lone Star Steakhouse. Lone Star Steakhouse was a successful restaurant and, hugely successful. They opened a couple locations. Turns out there was another Lone Star Steakhouse that opened up probably in Texas. I don't know where they actually opened, but I would guess Texas. The restaurant in Arizona was using it way before their other one, but they never did anything to protect it nationally. The Texas group filed trademarks and started opening restaurants all over, and these guys got ticked and tried to sue them, and they lost because they couldn't prove that was their market out there. Their market was relatively localized, even if it was the entire state. If they had filed a trademark federally, it blankets the entire United States, whether you're using it in that state or not. So it gives you a presumption that you're using your mark in commerce throughout the entire United States. So if I create whatever your company name is, if I'm selling a product with that, and so far my first sale is just in Arizona, if I file a federal trademark registration, then people can't use a conflicting mark in Florida, for example, even though I've never even gone there. I can stop that. So that's the benefit of filing. That's why you would want to file. And then the final type of thing that I mentioned is just trade secrets. And there are some things like the recipe for Coca-Cola, right, that it's not patentable. You can't file a trade. I mean, they have a trademark for when you're selling it, but it has nothing to do with the recipe. And you could copyright the recipe if you wrote it down, but that would defeat the purpose. If you wrote the recipe down and then filed it with the Copyright Office, everybody would be able to see it. So they just keep it secret. That's a trade secret. And trade secrets, as long as you take precautions to keep them secret, there's laws that protect people from stealing your trade secrets and using your trade secrets. So if someone like corporate espionage sneaks in and they learn something about that you keep as a trade secret, and you sue them, as long as you can demonstrate that if anybody has access to it, you make them sign NDAs. You've got some process internally where you stamp really highly confidential stuff, that it's confidential, and you have safeguards in place. In other words, if you treat it as confidential, then the law will also respect that. And you can stop someone from using it. You can sue them for damages and things like that. So a lot of times even if you can protect something, companies make the decision that they think they can protect it just as well by keeping it secret. And so they don't file anything. So there's things that are even patentable that people make the decision not to file a patent on. So those are the buckets. So you have those buckets, right? Those 4 buckets. And you think about where they belong. This happens a lot. The reason why that's important is because sometimes you'll go to another company that you're going to enter into an agreement to co-develop something together. And it's important to know what you had when you entered into the relationship, and it's important for your other party to know, because once you start working together, then you got to decide any new creations that come out of what's been worked on together, who owns that? And so what you do with those buckets, you identify what is, in the contracts we call it background intellectual property, background IP. That's what you owned going into the relationship. And then you create a definition around something that's jointly created. And you define who owns it, who has the right to use trade secrets, who has the right to file patents, who has the right to create products. It could be both of you, it could be one of you, and the other one gets a license. There's a lot of interesting things that come from that. One of the biggest things I've done for ASU was, it took about a year to work on this. I don't know if any of you are familiar with the Flexible Display Center. It's at the Tempe Research Park, or at the ASU Research Park on Elliott. Well, that was something I worked on. It was a joint venture with ASU, Honeywell, a lot of big companies, and all these companies were coming together, and they all had some, IP for flexible display screen technology to be used in, for computers. And what happened is the Army, they wanted their soldiers to have computers that you could roll up in backpacks, you could wear it on your sleeve. I mean, screens that were very durable and flexible. And it might seem like a dinosaur now because it was probably 12 years ago when we did that. But the Army, all in, put in $180 million. So, and let ASU won the bid, and ASU was charged with putting together an agreement with other companies that had parts of this technology. Honeywell was a big one. And back then Kodak, which is no longer, doesn't even exist. But all these companies had some IP, and we had to negotiate an agreement where they'd all put their IP in, and they'd collectively develop this flexible display screen technology. So you can think about it, with all these big companies, it's like who owns what, who gets to use what. Nobody had the whole, but once everybody put it in together, there was this whole, which was a flexible display screen that was created, and ASU created an assembly line over there at the Flexible Display Center, and sold, and the Army could then buy these display screens. That's all they wanted. They said, look, we know this technology's out there, nobody's ever put it together in the right way, so ASU, we're going to give you this money, you pull all these people together, you create an assembly line, and start creating flexible display screens. And so that's what we were charged to do, and we had to negotiate, who owned what IP. And so it can get quite complicated, but more and more in today's world, that's the core asset of the business, the IP. So, we were talking about this. In this space, the cosmetics and beauty, one of the founders in this, she used to call me up almost every weekend with like 10 new product names because she dreamed them up. And it all came from this book that she found in Europe that had come off copyright because the author had died way back. And that's one of the things we had to find out. She said, can I use all these names? The book was called Philosophy. So if you're familiar with the company Philosophy, the book was called Philosophy, and it was these little one-page things that someone had written, that are now product names for all the products. And there's more products than that, but that's what, sort of gave her the idea. And so she launched the company around this idea, Philosophy, and then each product name. And so it was like crazy stuff. But the reason why I'm mentioning that is for certain, like definitely in the health and beauty with cosmetics, things like that, the brand is critical, right? Because a lot of the formulations, they're all the same ingredients. It's just how you brand it, how you put commercials on with the right people, and at Christmas time you have some star, They name a fragrance after them, but it's all the same chemicals. And it's and there's really like, 10 people in the world that do all these formulations for all the companies. So they just put their brand. So the brands become really important. And just to give you an anecdote for that company, because it's been sold, so I can talk about it a little bit now. But we were filing. We probably had, 500 or so trademarks, and we were filing. We had a certain decision process, right? Because it costs money to do this when you do it on a big scale. And so you got to say, okay, which one? It's sort of like what ASU does when they decide which things to file patents on, right? Because now it's focused on, can we commercialize that? If we can't commercialize it, we're not going to invest money to spend. And you can go file your own patent if you want, in which case we'll give it back to you. So if they want it, they'll spend the money to file a patent on it. And that can be quite expensive. So in the cosmetic space, these brands, you file them, and you can file one of two ways. I didn't even cover this, but it's important. You can file as an intent to use, so that means even if you're not using your brand on your product yet, but you intend to, you can file it that way and protect it as of the day you file. You just have to follow up. Once you start using it, there's a time period in which you have to start using it, and then you file to say we're using it. If you don't use it by that date, you lose it. But you can file in advance as an intent to use filing. So that's what we did for some of these ideas, because we never knew we were going to invest the money to actually create the product. We had one for a sunscreen called Shelter. Seems kind of like, ooh, obvious. But and so all we did was file an intent to use application, and we'd never developed the product, but it was in the queue as one of the things we might do. Somewhere along the line, we get a call and then a letter from one of the big cosmetic companies, and they're freaking out because they had a whole product line that they invested millions of dollars in called Shelter, but they never did anything to protect it. So they're calling us to beg us to give them the name back. And so we were getting faxes. Like the first fax would be, we'll give you $500,000. Second fax, we'll give you $1 million. We literally were getting offers for a couple $1 million for something we never did anything with. It was just a piece of paper we filed to protect it. So it just shows you how important that is, because they had already invested. They had products ready to go to market. Their labels were all done, packaging. Somebody screwed up along the way and didn't protect it. And so now they were scrambling. And so it's kind of nice to be a little startup company to tell these big companies to go pound sand if you want to, because you're in control of something that's very valuable. Anyway, so the technology for most of the companies that you would probably be involved in, even if it's like a consumer product, intellectual property is still important because of the branding and the trademarks and the formulations. A formulation can be a copyright if you write it down, but a formulation is really a trade secret. Most of those formulations are trade secrets. How you mix the chemicals in order to create a certain scent, or how it feels, the texture, and stuff like that. So that's all intellectual property. Anything else? I could talk about anything because I've been doing this forever.
And I have
so.
a lot of great
I
information.
know.
Yeah, I've got a lot of stories too. My only fear is this is being taped.
Yeah, could be one done being taped.
Could have a bestseller, huh?
Yeah.
Change the name and dates to protect you.
Yeah. 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 So, yeah, I can tell you about a recent success story that I represented one guy was an engineer. He was one of the early engineers out of Vince Pizzicone's lab. And he teamed up with a neurosurgeon at Barrow. And the neurosurgeon, they were at lunch, they were friends, they were at lunch, and the neurosurgeon was complaining and gave Neil Crawford the idea. They started putting it on a napkin. And because Nick Theodore was the surgeon, he said, whatever the problem was, he was kind of complaining about it. Saying, I wish we could do this, wish we could do that. And Neil, being the inventor engineer, is like drawing it up, seeing if they could do it. I think we can do that. I think we can do that. And so they got together and they formed a company, and they got what the product was a surgical assist robot that assisted with spine surgery. So the problem is, when spine surgeons are drilling in to figure out how deep the screw goes, they have to go in multiple times, and they just go a little bit, and then they would take x-rays, then they go a little bit deeper, take x-rays, because you can't mess up. You hit a nerve or something, you've really messed up. So it's very complicated, a lot of x-rays, a lot of bad radiation involved and stuff. And so they had this idea for a robot that would geosynchronize with the Earth, and so any movement it would automatically adjust, and it could, with precision, drill in one shot right to the very spot. Way more accurate than human. Anyway, so they created this, and they drew it up, created the first demo on the computer, and we raised some seed funding from, surgeons and different people that were relatively low-hanging fruit. And I think they raised a total of about $1.9 million altogether. And they were in the process of creating the second gen on the computer, still no hard prototype. And there was one company that was ahead of us that had the Da Vinci robot that was selling for $1 million a pop. That company ended up selling to Stryker for I think it was 18 times revenue. So it was a crazy number. That's a huge multiple. It was several $1 billion sale, I think. Anyway, and there was no one else out there. And so all the other medical device companies decided they had to have a robot too. So they're looking around trying to find other companies, and they found us. So we started getting offers like crazy. They ended up selling the company. So here's the thing that's funny is they raised the seed money. They hired regulatory people to help them do a path to get FDA clearance and stuff. And we literally had our first board meeting. They had some outside board members that were pretty high profile people. And we sat down at the board meeting, and they're talking about, all the stuff they're going to do. And they kind of laid out, here's what we're going to do to grow the company. And they, left, and then they came back the very second board meeting. It was about a month later, I think. The only topic for discussion was sale of the company. So, they sold it, wasn't FDA cleared, they all became millionaires, and it was all just based on, pursuing the dream, going forward, and creating a plan, and then the market. I mean, the most important thing about success or failure is being in the game. I mean, literally. There are so many stories I could tell you about people that never expected the good fortune to land on their lap, and if they didn't do the hard work to get to the point where they were at, they wouldn't have been able to do that. So the most important thing is just get in the game. If you really have an idea and a dream and you're working on something, then get in there and just get started. I have a client that has sold 7 companies, and he's had many thousands of employees over his life. He's kind of not working anymore. He's older, but his motto was always just go into work every day and work hard, and good things happen. So you got to grind it out. That's what he would tell entrepreneurs. Just get in there and work hard every day. Eventually, good things happen. So it's hard, but that's kind of what I always tell people, the approach, because there will be a lot of struggles. And anyway. By the way, I love working with entrepreneurs. I actually, when I was in college, I started a company with a friend of mine. It was a complete failure, but we spent all of his uncle's investment money. But over the years, because I work with startups a lot, I probably do about 30% of my time investing in companies now. I form funds. I have 3 large, wealthy people that invest in startups. 3 billionaires, I should say. I mean, I have a lot more than that, but 3 of them that are of that size. So, I do a lot of things around investing, a lot. And so, if you ever need any advice or thoughts, if you're thinking about raising money or whatever, just reach out. I'll help you out. I'll chat with you and see what I can do. Anything else? Is that good? You guys got to get pizza? Isn't that what you do?
Yeah, isn't that what you do?
Yeah. So I didn't mention my son. He knows my son Nick. That's kind of how I got connected to Draper. He went to Draper when he was younger. He's a PhD student here now.
Oh, nice.
He's working on something neuro ultrasound stimulation for the brain.
Oh, cool.
And he's working with a guy, Jamie Tyler, who's an interesting fellow that was at ASU, and he left to do a startup, raised $40 million of venture capital from KOSLA, and failed. So he's back here. He calls Nick up and says, "Hey, I'm opening up a lab. I hear you're interested in this. I'd like you to be one of my PhD students." So Nick stayed here. He was going to go to Duke, actually, it's a great school, but he would have probably been pushed more towards medicine, and he doesn't want to do medicine. Anyway, it worked out really good. But the other thing, I mean, you guys probably hear this stuff from people, but we don't appreciate it as much here, like in Silicon Valley. Failure is actually a good thing when you're young. So you should never feel bad about failing, because actually, as you mature, if you've had a few failures, that's actually an asset. So investors will look at you. If you haven't had any failures, they actually ding you for that when you're older. So they want you to have had failures. So, in fact, I've heard Vinod Khosla say this, that your past failures are one of your greatest assets. So they look for that. Because think about it, it makes sense. If you failed, chances are you won't do that again. Whatever it did that caused you to fail, if you're a smart person, you'll learn from it and you won't do that again. So I think of that a lot when I have first-time entrepreneurs. It's like, for me, when I sit down with an entrepreneur, if they've never done it before, because most of my work is with serial entrepreneurs. We'll do like 20 startups at a time that are first-timers, our firm in general. But when you're sitting down, it's like you're looking at the person, and this is how your investors, your partners, whoever you're going to do business with, this is the way they're going to be thinking. They're looking at you, and if you haven't done it before, they're saying, do I really want to go through this with this person? Because I know you're going to make mistakes. And so it really comes down to, if you're pitching investors, or even someone you want to do business with, or if it's a good lawyer you want to use, or whatever, just keep in mind, if you haven't done it before, the biggest things that I think you should bring out in your conversations and demonstrate is, number one, you have to have a passion. You've got to demonstrate that you're passionate about it, that you're committed to this, and no matter what, you're going to do it, even if you can't. I mean, but you have to be totally passionate about it, because if you're not passionate about it, the other person's not going to be excited. And then second thing, so passion, and the second biggest thing is really, it's hard to demonstrate this, but keep it in your mind so that when you have opportunities too, when people ask you questions, is your character. Character is so important. If you ever fluff, you overstate something, you misrepresent it, or you make it sound like it's better than it is, and they find out it's not, you're dead. So it's really, especially for things that aren't good, if they say, well, you don't have this covered, or let's say, I'll just use a stupid example, but like the computer code, if you haven't done your stuff properly and you finally come to learn that, oh my gosh, I got to document all this, so you get everybody to sign, but there's somebody that worked on a piece of the code that's in Argentina or something, you can't reach them. And the investor says, can you document that, everyone has signed off on the IP? You definitely want to tell them, we have one that worked on some of the code. I mean, you have to bring out your bad stuff, get it on the table. But you don't just leave it there. You say, yes, we have it all documented, but there's a part of the code that we didn't get the person to sign that created it, and they're gone. But here's how we're going to overcome that. It's a small part of it. We're rewriting it. Whatever your answer is. But that's way better than fudging and saying, yeah, we've gotten all our people to sign, hoping they won't see it. Because if they ever do see it, you're dead. They'll never talk to you again, and they'll tell their friends. So character is critical. So I think, if you don't have a lot in terms of what you've developed so far, you don't have customer traction, all the typical things they would look for to put money in your company, if you can demonstrate passion and your character, they're willing to spend time with you to help you. By the way, most investors are entrepreneurs. And so the thing you have to learn is when you're talking to them and you don't have a lot, you're not real far down the road with your company or whatever, the thing you need to understand is they are entrepreneurs and they have the same gene inside of them that you have, meaning I believe you're born with a gene that somehow manifests itself if you're an entrepreneur. And it will eat away at you until you try something.
Yeah.
So you either have that or you don't. Some people don't have it and they could care less. But if you have it, if something's bugging you and you really want to try something and you want to create it and you want to try to create a company around it or whatever, it'll just eat away at you. You'll either regret it or you'll do it. And most entrepreneurs at some point will do it. But the point is, these people that you're talking to, even if they're, three-piece suit investors from New York City, I don't care who they are, the reason why they're talking to you is because they have that same gene in them. And usually they've started companies, and that's why they're rich, especially in the venture capital world. So it's all you need to do is appeal to that and get that fired up in them and make them believe that you have passion and you have character, and they're willing to spend time with you at that point. Because if they see your passion and you fired up that gene in them that is inside of them, they'll help you. And they'll come in at an early stage, and you'd be surprised what can happen. So just keep in mind that the other person on the other side of the table, for the most part, if they're investors, they get passionate about the same things that you get passionate about. So it's kind of hard to think of it that way when it seems like they've succeeded and they have all the money. But the reality is, it's not the money, it's they like being in the game and being part of the whole process. Yeah, they like to make money, but the reason why they're in this field versus something else is because they get fired up by the stuff you're doing. So anyway. Good?
Yeah, great. Thank
All right.
you for your time. I appreciate it.
Okay.
I had
You're welcome.
questions for you, but you answered all of them.
I know.
Okay.
So, like,